Hi, my name is Nilo Sanchez. I'm an attorney here in Tampa with the law offices of Sanchez and Associates, and with me today is Vanessa Fernandez, who's also an attorney with our firm. And we thought we'd sit here today and talk to you about some of the demands that we see and what we address on a daily basis and representing clients in matrimonial and family law cases. So one of the issues that very often comes up is whether something rises to the level of an emergency or not. And after having practiced for many years, I will tell you that it's a very difficult decision to make. The courts set a very high standard before a matter is considered to be an emergency. So to that end, I'd like to ask you, Vanessa, from your experience, what analysis do you go through in order to assess whether something rises to the level of an emergency or not?
There is case law in the state of Florida that is helpful in defining an emergency. Typically, unfortunately, an emergency is considered when the child is in danger of harm or being removed from the state, or a parent does not know where their children are. Unfortunately, outside of an intense situation like that, oftentimes the court doesn't view most situations as an emergency. So, yeah.
What, in situations where it doesn't rise to an emergency, but yet it's still an urgent matter, what, if anything, have you done in your practice to try to increase the likelihood that it could be seen and heard by the court sooner than it would in the ordinary course of the cases?
Definitely. Sometimes I'll request expedited time as opposed to emergency time. Also, requesting a brief hearing where you can quickly present your evidence allows you to get scheduled sooner. I also find that attaching exhibits to motions, if I have them, such as photos of things that may have transpired, often helps the court process what's in my motion and my request to be heard sooner.
Right. Those are all great suggestions, and those are matters that require a lot of consideration with your attorney in going through the facts and going through the analysis of that situation. And one thing you want to do is you want to make sure that you do never fall in a trap where you're going to be viewed as a person who's crying wolf, because you could lose credibility very, very quickly with the court. At the end of the day, what the client feels is an emergency, what we feel is an emergency, and what the judge feels is an emergency are three different standards. And ultimately, it's up to the court as to whether something rises to the level of an emergency. We recommend that if you're in that situation, and we hope that you're not, but if you're in that situation, please give us a call here at the law office of Sanchez and Associates, and we'll be happy to discuss this matter with you. Thank you.